Good afternoon, everyone. It's 12:30 on the dot. For those of you, I can't see you, unfortunately. Hopefully you can see me. I'm Krista Gruen. I'm a lawyer here at SBA. And with me here today is Fiona Brown. Even if you can't see her on your screen, she's here, but you will see her when she starts to speak. So on behalf of Fiona and I, hello and welcome to the third installment of our Occupiers Liability Lunch and Learn webinar. Last year, Fiona and I put on a webinar regarding the updates to the Occupiers Liability Act amendments involving snow and ice claims. So we're continuing with the occupiers trend today, this time with a focus on summary judgment motion trends. For those of you who don't know, Fiona and I have overlapping practices primarily focused on defending personal injury claims, including the occupiers context under both CGL and homeowners policies, as well as other areas of PI litigation, such as MVA claims. Hopefully you already know our firm, but just in case, a little bit about us. SBA is an insurance defense firm. We have 3 offices, one in Toronto, one in Kitchener, and one in London. We're now at 23 lawyers and soon to be 25 in June. So a very exciting time for all of us as we continue to grow. Just a reminder, webinars that we do are always recorded, so you can always find them after. If you didn't catch the whole thing, we'll post them on the website, or if you have a colleague that you think would be interested, please let them know as well. We are happy to share a copy of our slides, so if you'd like that, just please reach out to Fiona or I after the presentation. So as we go forward, not sure if you've been on the SBA website lately, but if you have, you'll probably notice that we've rolled out a new theme, which is cute animals. One thing that unites all of us, other than being lawyers here, is our love for animals. So who doesn't love them? We hope you enjoyed just as much as we do. Before we get into our topic, though, a couple of housekeeping items I wanted to mention. Questions. There's an opportunity for a Q&A at the end of our talk. We're happy to address those. You just enter them in the box on your screen below. And we also have a number of polls included in today's presentation, but they are very quick and very easy. We do encourage you to answer them when they come up, and hopefully we can keep things as interactive as possible. So a little roadmap of where we're going to go today as we cover the topic of summary judgment motions. We're going to start just with a quick refresher on what the test for summary judgment motions is. Then we're going to touch on 5 different cases that have come up within the last 2 or 3 years and how each of them have dealt with summary judgment motions a little differently. And finally, we're going to share some takeaways. So I'll cover the first couple of cases after I give you a little refresher on the test, and then Fiona will take over for the balance of the cases and some takeaways. So summary judgment motion tests. Before we get into the cases themselves, in a slip and fall case, like the ones we're going to talk about, you would typically bring a motion for summary judgment under Rule 20 of the Rules of Civil Procedure after examinations for discovery. So that's when you have the bulk of the evidence that you need for the test. When bringing summary judgment motions, you are expected to put your best foot forward. That's been very clear in the case law. You're also expected not to waste any time once you have sufficient evidence to bring it. The basic test, though, as we probably all heard already on summary judgment motions, is whether there is a genuine issue requiring a trial. According to the Ontario Court of Appeal in a 2011 decision by the name of Herniak and Malton, the big name that you'll hear a lot with these types of motions, the test for summary judgment motions is that the judge has to assess whether they can achieve a full appreciation of the evidence and the issues required to make dispositive findings on the basis of the motion record. That might be supplemented by oral evidence under Rule 20.04 sub 2.2, or if the attributes and advantages of the trial process require that those powers only be exercised at trial. And then in 2014, we have the Supreme Court of Canada come along with their decision in Herniak, which many thought would mean that summary judgment motions were going to be used more often in an effort to use them more broadly to ensure fair access to the affordable, timely, and just adjudication of claims. However, in the cases that followed Herniak, we saw many examples of where summary judgment motions can actually slow down the process if they're used incorrectly. So you'll see as we talk about the cases, this push versus pull effect is pretty apparent, as we'll see. Then we see a case called Wardak and Froome from 2017. It's an Ontario Superior Court decision. And in that case, they talk about the procedure to be followed in a motion for summary judgment as outlined in Herniak. So really you're looking at two stages. The first one being the judge should first determine if there is a genuine issue requiring a trial based only on the evidence before the judge without using the fact-finding powers in Rule 20.04. And second, if there appears to be a genuine issue requiring a trial, then Rule 20.04 permits the summary judgment motion judge at their discretion to 1, weigh the evidence, 2, evaluate the credibility of a deponent, or 3, draw any reasonable inference from the evidence, unless it's in the interest of justice for those powers to be exercised only in a full trial. So just keep that test in mind as we go through the cases below. This is just a quick little overview. You don't need to be scribbling down all the citations. As I said, we're happy to share these with you. So the first one I'm going to talk about is a case by the name of Webster and Interactive. It's a 2020 Ontario Superior Court case. And in this one, I'm just going to give you the basic facts. Plaintiff attends a heavy metal concert. Shortly after the music starts, he's found lying on the ground, severely injured, surrounded by a crowd of people, doesn't know what's happened. The incident, unfortunately, resulted in him becoming a quadriplegic. He sued multiple defendants, including the venue, the security company, for the alleged negligence, occupiers liability, and breach of the Ontario Liquor License Act. The defendants then brought a summary judgment motion to have the claim dismissed. The defendants argued that the plaintiff couldn't prove what specific act or omission on their part that had caused the plaintiff's injury, and that the plaintiff hadn't put forward any credible theory as to who or what caused the injury. So this brings us to our first poll. Just based on those facts alone, do you think that summary judgment was granted in this case? Simple yes or no, no trick questions here. So I'll give you some time there to answer. Let's see what our results are. Okay, we've got 36% saying yes and 64% saying no. Well, to surprise you, maybe, yes, summary judgment was granted in this one. Justice Skarica granted the motion and dismissed the action, finding that the plaintiff had not provided a sufficient factual basis to establish that the harm was a reasonably foreseeable consequence of the defendant's conduct. He held that the defendants had acted reasonably in the circumstances, which was all that was required. With respect to the plaintiff's allegations against the security guards, Justice Skarica noted that there was no evidence of any of these alleged defects that contributed to the plaintiff's injuries. He added that there was no medical evidence indicating that the security guards injured the plaintiff by moving him after his fall. And as the motions judge concluded, there was no genuine issue for trial, and the summary judgment motion was successful. So this case is a reminder that the fact that a plaintiff sustains an injury on the premises, no matter how severe, doesn't necessarily equate to a finding of liability against an occupier. So obviously not to minimize this poor plaintiff's injuries, but we have happy dog for yes, and you'll see what we have for no a little later. So the next case I want to bring up then is Branton, and we'll call it EuroX rather than reading out the Ontario numbered company. This is a 2021 Ontario Superior Court case. The defendant was engaged in this one in some road construction work on the street where the plaintiff lived. At the time of the incident, the defendant was installing new curbs, and during the construction work, the plaintiffs didn't have access to their driveway. The construction created a temporary ditch at the foot of the driveway. In order to get access to the roadway, there was a dirt ramp, but the problem with the ramp was there was a drop off on both sides. So when the plaintiff was coming home, he attempted to get through that, ended up sustaining a left foot injury. He didn't know what caused him to fall, but indicated that when he stepped with his left foot, there was simply air. The plaintiff's engineering expert stated that the ramp posed a significant hazard. The edges of the ramp were not demarcated, and there was an excessive elevation difference and an excessive side slope. As well, it was found that the lighting in the area was low. So regarding whether the breach of the duty of care caused the plaintiff's fall, the plaintiff stated on discovery that when he attempted to step, he fell down, but he didn't know specifically what caused him to fall. So similarly, defendant brings a summary judgment motion. What do you think about this one? Another poll. Was summary judgment motion granted in this case? Yes or no? I'll give you a few seconds here to answer that. Okay, here's our results. Oh, I might have scared you with the last one. 18% yes and 82% no. Well, I can tell you the no's have spoken. You are correct. Sad kitten. Justice Mitchell in this one stated that although the plaintiff could not specifically comment on the cause of the fall, he did know the precise location of the fall. So that was a big difference with the previous one that I mentioned in Webster. And Her Honor indicated that it can be inferred that the drop-off on the side of the ramp caused the fall. So as such, she dismissed the summary judgment motion and granted partial summary judgment to the plaintiffs on liability, which was of course not what the defendants wanted. But this case does serve as a reminder that liability can be inferred based on the location and the circumstances surrounding the fall. So with that in mind, I'll turn it over to Fiona, who's going to lead us through the next three cases.
Hi, everyone. I can't say nice to see you because, as Krista said, we can't see you. But I was here, I have been here, and I'm really glad that you all joined us today. I'll get right into it. I'm going to talk about three decisions. The first one being Massaroni versus Yum Brands, Inc. In this case, the plaintiff was injured while walking from the parking lot of a KFC to a TD Bank. A curb and a 2-foot concrete retaining wall separated the two properties, and the judge referred to this area as the barrier. The plaintiff fell while crossing the barrier and suffered a fracture of her right foot and left ankle. The defendants brought a motion for summary judgment. Here are some of the facts. The plaintiff was 47 on the date of loss. Weather that day, there was no problems, sunny, clear. The barrier itself was made up of two different structures. On the KFC side in the parking lot was a typical concrete curb that we all see, about 6 inches tall, that extended alongside the end of the KFC drive-through entrance lane. Next to that curb was a 2-foot tall concrete retaining wall. There was a space in between the curb and the retaining wall of several inches. The purpose of the retaining wall was to be a barricade so cars couldn't drive from one property to the other. Of interest, there was a city sidewalk a short distance from this barrier that would allow the plaintiff to gain access to the TD Bank. On discovery, she said she fell about 10 feet away from that public sidewalk. On the motion, the plaintiff took the position that the barrier invited people to use the step as a shortcut between the two properties, and that many patrons had used the same route she was taking on the day of the accident. She claimed she'd crossed over this particular barrier 4 or 5 times in the past without any issues. The plaintiff also pointed to the discovery evidence of the representative who was produced on behalf of TD. He said in his affidavit in support of the motion that people might have used that barrier in the past, but he had not seen anyone doing so. 4 weeks after the accident, the plaintiff and her sister returned to the area, and during her examination for discovery, she claimed that while she was there, she saw someone crossing the barrier. But in her affidavit in support of the summary judgment motion, she said she didn't remember seeing that person crossing. There was no evidence in the area of a worn path, suggesting that lots of people were regularly going back and forth over the barrier. In response to the summary judgment motion, the plaintiff also claimed that the defendants had a duty to clear debris and pebbles from on top of the barrier, but they hadn't done that on the day of the accident. Okay, those are some of the main facts. What do you think? Was summary judgment granted in this case? "78% said yes and 22% said no. The answer is yes. Summary judgment was granted, and we have the happy puppy. So what the judge in their reasoning questioned, well, given that the purpose and function of the barrier was to prevent vehicles from driving from one property to another, why would the defendants have any duty to clear debris on top of that barrier? Even if there were pebbles on top of the barrier, that would in no way interfere with the suitability of the barrier to prevent vehicles from driving back and forth over the properties. The judge felt that the defendants might have a duty to fix the barrier. For example, if pieces of concrete were falling off of it that could damage vehicles. The judge felt it was important that there were no signs of other people using that area to cross, like a path. And the plaintiff's evidence of using it 4 or 5 times in the past without any incident suggested she should have been more careful in crossing the barrier and taken more care. I think what was really important in this, the judge's finding, was that the plaintiff provided conflicting evidence on how her accident occurred. On her discovery, she said she slipped on the curb, that 6-inch tall curb. But in her affidavit evidence for the motion, she claims she slipped on pebbles and debris on top of the retaining wall. So she clearly contradicted herself, and the judge made it very clear that they were not impressed with this evidence. And the plaintiff had every opportunity of correcting her discovery evidence if it was incorrect, as she's required to do, and she hadn't done that. So the judge felt this could be dealt with summarily and dismissed the plaintiff's action. The next case is Adler versus Promenade General Partner, Inc. In this case, the plaintiff, Eleanor Adler, and her granddaughter went to a movie at the cinema located in Promenade Mall. While walking near the food court after the movie, the plaintiff fell forward and she suffered significant injuries, including fractures to her face, a fracture to her skull, and her left kneecap. The plaintiff claims she fell because her shoe became stuck on something sticky on the walkway, which impacted her stride and caused her to fall forward. She sued the owner of the mall, the property manager, and the cleaning contractor, the usual suspects. The defendants brought a summary judgment motion seeking dismissal of the action on the basis that the plaintiff failed to produce any objective evidence of the presence of a hazard, and as a result was unable to establish any breach of duty of care owed to her. The defendants argued the plaintiff advanced a purely speculative account of how she fell. They relied on 2 prior decisions. I'm not going to discuss them, but I bring them to your attention. Nadlal and Toronto Transit and Hamilton versus Ontario Corporation. These 2 cases have very similar facts to the Adler decision. The plaintiff's evidence, I think, was important. She was wearing slip-on shoes at the time of the accident. They were in good condition. She testified she didn't know what she fell on. She saw nothing unusual in the area of the fall, saw no debris, water, gum, anything in the area where she fell. It was flat where she was walking, and she made no other observations of the area of the fall after her fall or before her fall. All she could say was she fell on the floor due to something being on the floor, but she couldn't say what that something was. On cross-examination on her affidavit, she was consistent. She said while walking through the food court, her foot got stuck on something. When she attempted to move her foot forward, her foot stayed stuck and she fell forward Again, didn't know what the substance was. So in response to the defendant's summary judgment motion, the plaintiff took the position there was a genuine issue for trial because it was reasonable for the trier of fact to infer that it was food or drink that had been spilled on the floor, given her fall occurred in the food court. The defendants argued even if there was such a hazard, they had a reasonable cleaning system in place on the date of loss and met all their obligations under the Occupiers Liability Act. So, was summary judgment granted? Yes, 43, no, 57. So we're pretty close on this one. The answer is no. Sad kitty. Sad for the defendants. So the judge distinguished this case from the two cases I referred to, Nadler and Hamilton, where summary judgment had been granted. Those two cases are similar in that the plaintiffs did not see what they fell on. In both of those cases, there was no evidence of something being on the floor, and the plaintiffs could not identify a hazard or an unsafe condition, but yet both cases, the plaintiff's cases were dismissed on summary judgment. The judge here said that in those two cases, the plaintiffs had not adduced any admissible evidence of a hazard. And in both cases, the plaintiff's evidence was speculative rationalization about what must have happened as opposed to what did happen. The judge felt in this case, the plaintiff wasn't trying to reconstruct what had happened, and she offered her own direct observations of a sticky substance being on the floor. According to the judge, her observations were that while she didn't see the substance, she could identify it, and could not identify it, she could feel it. And the judge felt that was enough to find there was a genuine issue for trial in that regard, because that evidence of hers is admissible. What was also important wasn't on top of her evidence was the fact the defendant's system of cleaning and inspection was found to be not acceptable under the OLA. They said they had a reasonable system, but they had produced a security video that showed the area of the fall a couple of hours before and a couple of hours after. The cleaning representative was shown that parts of that video on discovery and admitted that there had been no cleaning activity at all for a couple of hours before the accident and a couple of hours after. The cleaning representative also said that the cleaners were supposed to have cleaning logs to record any mopping or sweeping, and somehow those logs had been lost and weren't produced. So the judge felt that the evidence was far from clear that the defendants had a reasonable system of cleaning and inspection on the date of loss, and I think that in part contributed to the final decision. The last case I will discuss is Fernandez and City of Toronto. After a night of heavy snow, the plaintiff slipped and fell on a temporary walkway that ran adjacent to a construction site. She managed to get up and continue to walk to her doctor's appointment, and later on in the day, used the same walkway while on her way back to her home. The plaintiff sued the City of Toronto, the TTC, and Bondfield for damages. There was some dispute amongst the defendants about who was responsible for what, but in any event, they banded together and brought a motion for summary judgment. In terms of the facts, the construction site included a city sidewalk, which had been replaced with a temporary 200-meter walkway to provide temporary pedestrian access. And you can see the picture that was actually in the case. This fall occurred on December 11th. On December 9th and 10th, there was some snowfall, but on December 11th, a significant amount of snow began falling at 2 a.m. At 2 a.m. By 6 a.m., 12 centimeters had accumulated. At 6 a.m., 6 Bonfield, the construction company's employees, came out and were instructed to clear snow and ice from the site, including that walkway. They began clearing at 7 a.m. and they reached the walkway at around 9:30 to 9:45. Two laborers used a small skid steer tractor to clear ice and snow, and 4 workers controlled the pedestrian traffic. While the tractor was working, one of these laborers used a shovel to remove the remaining snow. Another one applied ice melt along the walkway by hand. The plaintiff lived close by, and she had walked along Finch between 9:30 and 10 on her way to her appointment, wearing new boots, not rushing. She got to the walkway at around 9:45. She saw a Bonfield laborer using a snowplow to clear the snow from the walkway. Other laborers actually told her to wait until the laborer using the tractor was finished. She stood there watching snow being removed and watched the other laborers using hand shovels to remove the snow. She enters the walkway and slips and falls on what she believed to be a snow-covered patch of ice. Was summary judgment granted? %73% yes, and 27% said no. Let's look. It's a happy puppy. The answer is yes. Summary judgment was granted. And I liked what the court noted, and I often have to remind plaintiff's counsel, but the duty of care of an occupier does not extend to the removal of every possible danger, and confirm that the standard of care is one of reasonableness and not perfection. For a plaintiff to succeed in an occupier's liability claim, the plaintiff must be able to pinpoint some act or failure on the part of the occupier that caused the plaintiff's injury. The court concluded here that there was no negligence and that the defendant's conduct was reasonable in the circumstances. Prior to the accident, snow removal work had been underway for 2 to 3 hours before the plaintiff arrived at the walkway. She stood there watching as snow removal work took place, and there was no basis to conclude the work was done carelessly. The judge specifically noted there was no suggestion that the plaintiff was careless either, that this was simply a case of an accident without anyone being careless, and that slips and falls are not uncommon occurrences during heavy snowfalls. And the summary judgment motion was granted and the action was dismissed. So you've heard 5 recent cases that some got summary judgment, some did not, but what are the takeaways? I think we have to keep in mind that a plaintiff's failure to see or identify what caused their injury won't necessarily be fatal to their claim. So before proceeding with summary judgment, defendants should carefully review the facts of the case to see whether the plaintiff does have direct evidence of a hazard, even if the hazard can't be identified. And as we saw, where the plaintiff just had a feeling of a hazard, that could interfere with the ability to get a summary judgment. Before bringing a motion for summary judgment, occupiers should ensure they have a strong evidence of the absence of a hazard or of a reasonable and operational system of inspection and maintenance of the premises. If there are no cleaning logs, that is going to be detrimental to getting summary judgment, or if there are gaps in the logs, that could also be a problem. As we saw, consistent evidence on both the plaintiff's side and the defendant's is going to be key. There's no duty to warn what a plaintiff should know exists. The plaintiff must be able to pinpoint some act or failure on the part of the occupier that caused the plaintiff's injury. A solid inspection system and solid records go a long way. And keep in mind that the system must be working. I often see an amazing contract that have a scope of work that is just fantastic. But when you actually get the evidence, you find that that scope of work is not being followed on the date of loss. So it can look great on paper, but what it says on paper has to be followed out on the date of loss. The plaintiff's injuries are a consideration before bringing summary judgment. Some judges will feel uncomfortable granting summary judgment when the injuries are serious and may prefer to give the plaintiff a chance at trial. It is a consideration. And I would say last but not least, cost is a factor. It can be expensive to bring a summary judgment motion because by that point, you've already had examinations for discoveries. A factum has to be prepared, an affidavit, and often cross-examination of the affidavits take place, which is like having a second discovery. So if there's only a very slight chance summary judgment will be successful, maybe hold off and don't take the risk of a summary judgment. Well, thank you very much. I don't know if there are any questions, but I think we have, it's bang on 1 o'clock. If there are questions, we do have time.
Thanks for that, Fiona. And I just want to say exactly that. I mean, that's what we see in these cases where things go wrong is people sort of roll the dice. And if you don't have all those key factors, that's where we see a little bit more hesitancy to using these motions. But I think in the right case, they're very, very well used and they're a great tool. So I did check the Q&A. It doesn't appear that we actually have any burning questions, at least not that come to people's mind right now. But I will say, you know, if anything arises on your claims or you think of something down the road, just reach out to one of us and we're happy to talk through an issue with you and work through that. So yeah, time flies when you're having fun. We always try to jam pack a lot into a half an hour. So thanks so much everybody for joining us. And we will have some more lunch and learns in the works. You should be getting an invitation for one coming in about a month's time or so. But if you do have any requests for topics, drop us a line. We're happy to consider those and put something together that you're looking for. So on behalf of Fiona, myself, and the rest of the firm, thanks so much, everyone, and enjoy the rest of your afternoon.
Thanks, everyone. Have a great day.